Hello and welcome back to Inside the Contract. We are still on season 1. This is episode number 9. Today's topic is EOT preparation, records, submissions, and strategy. Reference is made here to 2017 FIDIC Red Book, subclauses 8.5, 8.6, 20.2.1, 20.2.4. And other maybe relevant subclauses that may be mentioned throughout. In this episode, we focus on how to prepare a defensible extension of time claim under FIDIC 2017. Not how to argue delay in theory, but how to assemble records, structure submissions, and present cause and effect in a way that stands up to engineer determinations, DAB review, and arbitration scrutiny. Many contractors lose extension of time claims not because delay did not happen, but because they cannot prove it. In today's episode, we go deep into how to prepare an EOT claim under FIDIC 2017 using global best practices, forensic delay analysis, and real-world project experience. So what an EOT is and what it is not. An EOT is not an automatic compensation. An EOT is time, more time on the contract completion date. Under FIDIC 2017 Red Book, subclause 8.5 gives the contractor to additional time if the delay is caused by one of the following. This is, by the way, not an exhaustive list, but the major items. Under subclause 8.5, the contractor may be entitled to EOT if completion is delayed by, first, a variation. Again, I must note here that no requirement to comply with subclause 20.2 for EOT arising from a variation. Okay, we talked about this before several times. 2. Any other cause that gives entitlement to EOT under another subclause of the conditions. 3. Exceptionally adverse climatic conditions as defined. Read your contract very well when it comes to this item. 4. Unforeseeable shortages of personnel or goods caused by epidemic or government actions. Or number 5, delay, impediment, or prevention attributable to the employer's personnel, or employer's other contractors. But entitlement is only activated when the contractor follows clause 20.2 by given 28-day notice, detailed particulars, proof of critical path impact, evidence showing cause and effect. Okay? The phrase that decides EOT entitlement is critical path, which I call the core principle. While subclause 8.5 sets the contractual test as whether the event delays the time for completion, FIDIC 2017 also requires the program to show float and critical path or paths. Reference made to subclause 8.3. In practice, parties typically demonstrate delay to completion through recognized critical path delay analysis. So the claim must evidence cause and effect on completion. Okay? FIDIC requires proof that the delay affects the time for completion. Reference is made to subclause 8.5. In practice, this is demonstrated by critical path analysis. A good reference is the guidance of the SCL protocol and the AACE standards, as examples. If it did not touch the critical path, no EOT, no relief from delay damages. This is why poorly maintained programs destroy claims. Okay, guys, keep this in mind. Updated and well-maintained programs. So let's look at how to prepare a claim. Step number 1, the 28-day notice. Notice is the first EOT weapon. Under clause 20.2.1, the notice must be issued within 28 days, as we discussed before, as soon as practicable, but no later than 28 days. After becoming aware, or when you should have become aware of the event. It must reference clause 20.2, or best practice to expressly label it as a notice of a claim under subclause 20.2 and identify the event, dates, and likely effects. It must identify the event and dates. This preserves entitlement, even if details aren't known yet. Common awareness triggers. Examples: drawings due date passed, approval date missed, site access not provided, authority and OC delayed, employer change instruction affects logic, for example. Best practices according to the SCL protocol: issue early warning notifications alongside formal notices. Okay? Step number 2, building the evidence base. The big 5, I call them, evidence categories for EOT. First, baseline program, approved, must be approved, must be detailed, logic linked, and best to be resource loaded for added strength. Just for clarity, baseline and update programs should be sufficiently detailed, logic linked, and compliant with subclause 8.3, including critical path and float. Resource loading may strengthen evidential weight, but is typically an industry practice rather than an express FIDIC requirement. The program should reflect realistic durations, must have a clear critical path. This is very crucial. It should be approved by the engineer or the employer, or at least approved with comments, at least. 2, updated programs. Weekly or monthly updates reflect actual progress, capture logic changes, show float trends and slippage. All progress must be contemporaneously recorded. Okay? 3, records. You need a record for every claim sentence you write. Daily site diaries, manpower logs, equipment logs, site photos, inspection requests, material approval logs, RFI logs, emails and letters, meeting minutes, authority logs, testing logs, and anything of that sort. If there is no record, the delay does not exist in the eyes of the engineer or the DAP. 4, delay event logs. Every delay must appear in delay event register, risk register, correspondence logs. Number 5, cost records. Only, of course, if prolongation is claimed, which may include site overheads, prelims, equipment standby, staff costs. According to the SCL protocol, the strongest claims are those built from contemporaneous project records. Okay? Step number 3, perform delay analysis. Under AACE 29R-03 and the SCL protocol, the most credible methods are: first, time impact analysis, TIA. This is best method when delay event is contemporaneous. I must stress that FIDIC 2017 does not mandate any particular delay analysis method. In practice, decision makers often give greater weight to methods that rely on contemporaneous programs and records, commonly time impact analysis, where suitable, or contemporaneous windows analysis, provided the method is transparently applied and supported by reliable updates and records. This method is used heavily in mega projects. I have seen it prescribed in many of the modified contracts for mega projects. Okay. Second, Windows contemporaneous period analysis. This breaks the program into windows and measure slippage in each period. This is good when program updates are reliable, delays are distributed over time. 3. As planned versus as built. Only for simple projects or when the engineer or employer, for example, destroyed program integrity. 4. Collapsed as built. Okay, this is hypothetical. This is highly technical, used mostly in arbitration, less accepted during project execution. Okay, so the best practice rule: choose the method based on project complexity, not contractor preference. Okay. Step number 4: prepare and submit detailed particulars. 20.2.4. Under subclause 20.2.4, detailed claim must include narrative of event, chronology, dates and milestones, contractual basis, for example, clause 8.5 plus 20.2 plus any other relevant clauses. Delay analysis, as I said, the TIA is recommended. Impact on critical path, updated program, evidence from logs, photos, RFI trails, etc. Cost, if applicable, mitigation measures taken, statement of continuing impact, okay, if the impact is ongoing. The deadline, within 84 days from awareness, not from the date you submitted your notice, okay, unless, of course, the engineer extends it. Under 20.2.4, if the required statement, including the contractual and legal basis component, is not submitted within the time limit, the notice of claim may be treated as having lapsed, subject to the clause notice and review mechanics. Important things to mention: that when the 84-day requirement did not exist in the same structured form under 1999 clause 20.1. The 20.17 is more procedural, consolidated, and maybe more enforceable. However, I'm saying this again in abstract terms based on the wording of the clauses, without implying legal enforceability outcomes. Those depend on governing law, tribunals, and etc. Step number 5, engineer's determination. Subclause 3.7. After receiving the claim, engineer must consult both parties. 3.7.1. Facilitate agreement. If no agreement within 42 days, issue determination. 3.7.2. Engineer's determination must be fair, neutral, contract-based, evidence-based. If contractor disagrees, submit a notice of dissatisfaction within 28 days. Then proceed to the DAP action under clause 21. This protects your rights, okay? Just to emphasize more in terms of practice, the engineer must consult and then make a fair determination in accordance with the contract, with reasons and supporting particulars within the applicable time limits, okay? So let's look at some case studies, referencing the project patterns observed here in the GCC area. On one particular mega project here in the Gulf region, contractor claimed 120 days. Engineer awarded only 25 days because no critical path proof, no TIA. Argument lacked quantification. So, and poor records. Lesson: magnitude of delay does not equal entitlement. Another case, some mega projects in Qatar. Authority delayed approvals, 55 days. Contractor issued prompt notices, kept detailed design logs, and performed TIA. Decision makers awarded full EOT, but no prolongation due to partial concurrency. Lesson: perfect records plus strong TIA equals strong outcome. Another project here in KSA. Employer repeatedly delayed interface handover. Contractor issued roll-in notices every 14 days. Engineer accepted the validity of the notices and substantial EOT. Lesson: roll-in notices are essential for continuous delay events. Another case, design build project. This is under the yellow book. Engineer delayed design approvals, but contractor failed to update program for 3 months. The result: engineer rejected EOT, decision maker upheld rejection, contractor was held responsible for the delay. Lesson: delayed program is a dead claim. Okay, keep that in mind. So let's look at the best practices for strong EOT claims. Issue early notices, keep daily log culture, maintain an approved and updated baseline. Use the correct and agreed delay analysis method based on your contract wording and specific schedule situation. Maintain a delay evidence binder, maybe digital and physical. Align planning and contracts team. Keep authority logs. Submit rolling claims for ongoing delays. Track engineers' response deadlines. Maintain claim and delay event registers. Okay, I have talked about this several times, but it's good to keep reminding people. So in order to close, winning EOT claims is really a science. It requires record plus programs, procedure, and analysis. With strong evidence, timely notices, and solid delay analysis, your EOT becomes a matter of logic, not just negotiation. Okay? By this, we come to the conclusion of episode number 9. In episode 10, we conclude season 1 with the backbone of all claim success: registered and tracking tools. Thank you for watching, and see you next time.